This is Bloomberg Law with June Grasso from Bloomberg Radio.
I'm sending in this video from California this morning to let you know that I accept this unexpected honor.
When Robert F. Kennedy Jr. accepted the nomination to run as a candidate for the Libertarian Party, he was at home in California. And a lawsuit claims that Kennedy's actual residence is in California, and that he misled voters by claiming that his residence was in New York on the tens of thousands of nominating petitions submitted to place him on the ballot in that state. Following a short trial, an Albany judge agreed that the New York address on the nominating petition was not Kennedy's real residence, but rather a sham address he used to maintain his voter registration and to further his political aspirations. And on Monday, Judge Christina Reba invalidated Kennedy's New York State nominating petition, ruling that, quote, using a friend's address for political and voting purposes while barely stepping foot on the premises does not equate to residency under the election law. In an interview with CBS 6 in Albany, Kennedy compared his situation to that of his father, the late Senator Robert F. Kennedy, when he ran for the Senate in New York.
He was also, ironically, called a carpetbagger. In other words, that he didn't really live in New York State. So 6 years later now, I'm running and I'm being told I don't live in New York State. My driver's license here. I vote in this state. My car is registered here. My law license is in this state, not California. My law office is in this state. I pay income tax in this state.
Kennedy acknowledged the decision could create problems for him in other states. He's currently facing challenges in more than half a dozen states, some alleging that he falsely listed the same New York address. He appealed the decision today to the appellate division in Albany. Joining me is elections law expert Richard Briffault, a professor at Columbia Law School. Rich, how is residency defined under New York law for election purposes?
Residency means domicile, which is the place that you maintain as your home, and if you are away, you intend to return to it. New York law recognizes that people can have multiple residences. You can have a main home and a summer home and another home, but one of them has to be the place that is your primary residence. In legal terms, your domicile, kind of the place that you keep as your home, and when you are away, you intend to return to it.
Kennedy listed as his residence a friend's house in Katona, New York, where he said he rented a bedroom. But he admitted at trial that he only spent one night there. That was about a month ago in June. There's no written lease.
It was actually after he had already filed giving the place as his residence.
There's no written lease. He only made a rent payment after a New York Post story came out. He moved with his kids and his pets, except for the Falcons and the Hawk, to California in 2014. He bought a house there. And when asked at trial if he lives in California, he said yes. And when asked if he has a physical presence at the house in Bedford, he said no. I mean, what is his reason for claiming New York residency?
Oh, his reason, I think, is that his running mate is a California resident, and under the Constitution, should he win any electoral votes, the California electors cannot vote for both of them. In other words, if he somehow carried California, the California electors are prohibited by the Constitution for voting for two people from their own state. So he had to have a separate residency from his vice president.
Well, the judge said that he demonstrated a long-standing pattern of borrowing addresses to keep up the appearances of New York residency. I mean, at one point, he claimed residency at a house that his sister had sold, and neither of them lived in anymore.
Apparently, he's still registered to vote in New York. He has a New York driver's license, and he has some other New York connections. And in some kind of fairness, he was a New York resident for a long while and had a lot of connections to New York. But yes, as I think the judge found, for quite a long period of time recently, he's been living in California with his wife and children and pets. And California has, I think the court found, and it seems reasonable, has been his principal residence for the last several years. And as the court said, you need a specific place for it to be a residence, not some general geographic area. Like he's had connections to New York, but you actually need to have, as the court says, a specific abode in New York in order for New York to be a residence, and he doesn't have one.
So some of the reasons he claims residency are he has New York State fishing and falconry licenses, a New
Right.
York State driver's license and vehicle
Right.
registration, a New York State voter registration, a license to practice law in New York, and he pays New York State taxes. Do any of those count toward residency?
They will all be relevant if he actually had a home in New York. I mean, again, I think if he had an actual home in New York and as well as an actual home in California, it would support his argument that New York is his primary home. But the problem is he has no home in New York at all. So, I mean, I think those would have been relevant if it was more of a contest as to whether or not New York or California was his home. Because as you know, a number of people have homes in more than one state. And so that would be relevant to deciding, for example, whether or not if you maintain one residency is, in one state, let's call it a vacation home, or a summer home in a second state, and you wanted to argue that the summer home was your real home. If you had a lot of connections to the summer home state, you might be able to be persuasive that you could choose that as your home. But in this case, he had none. He had various legal ties to New York, but the law requires that he actually have an actual physical residence in New York, and that is one thing that he does not appear to have.
Is the law pretty clear on that?
The language the court uses is your residence is where you maintain a fixed, permanent, and principal home, where if you're temporarily located somewhere else, you intend to return to that home. So it uses the phrase fixed, permanent, and principal home.
And as far as the spare bedroom that he was supposedly renting out, court said, quote, the court finds Kennedy's testimony that he may return to that bedroom to reside with his wife, family members, multiple pets, and all of his personal belongings to be highly improbable, if not preposterous. I mean, when you look at his testimony and the testimony of other witnesses, it seems almost like an open and shut case, and that the judge didn't have very far to go to make her finding.
I think that's right. I mean, in some sense, the judge's first point was how strictly or loosely do I have to interpret residence? And as she says, under New York State law, under New York Court of Appeals decisions, some election qualifications can be interpreted loosely, but these very formal, specific ones have to be interpreted strictly so that the courts are consistent from case to case. So the first thing is you really do have to show that you're a resident. And then she went through what that entails, and then there was extensive testimony from all the people who are arguably providing him a home, and it was pretty clear that his connection to the place he's claiming to be a home is extremely attenuated. As he pointed out, it's one bedroom in somebody else's house. He's only been there one night in the entire time he's had a connection to it. He wasn't paying rent until this case became a case, and then he paid it retroactively, back rent. And the home itself is under foreclosure. And as she points out, he has an entire household in California, and it just seems unlikely that if he were to return to New York, he would be returning to that one bedroom with his whole household.
He also claimed advice of counsel, that his lawyer told him this was okay.
It doesn't work. I mean, he's not being prosecuted for lying. It's just that he had to fill out a form, and he filled out the form inaccurately.
So he's appealing the decision in New York Appellate Court, and his legal team has said they're going to seek injunctive relief in federal court. And they're arguing that the U.S. Constitution's 12th Amendment governs the residency of presidential and vice presidential candidates, not state law. And they made a similar argument before the judge in New York who rejected it. What do you think of that argument?
It's kind of a red herring. I mean, yes, New York State could not require him to be a resident of New York State. That would be unconstitutional. But New York State is not doing that. New York State is simply saying, in order to get on the ballot, you have to fill out a form, and you have to fill out the form accurately. And the Supreme Court has, in the past, recognized that states can set their own rules for getting on the ballot, provided that they're reasonable rules, that they're not unduly burdensome, that they're not too hard to satisfy. You couldn't require somebody to have a humongous number of signatures in a very short period of time. That would be too burdensome. But I think a rule that simply states you have to put down your place of residence is the kind of rule that would probably, for most candidates, is not unduly burdensome. And the court has recognized the right of the states to, in effect, require certain forms to be filled out in order to get on the ballot. So, just to repeat, he does not have to be a New York resident, but he does have to fill out the form correctly.
Could this open him up to challenges in other states? Because apparently his campaign used the same address to gather signatures in other states?
Yeah, that's an interesting question, and I would break it up into a couple of parts. So in a number of states now, he is actually on the ballot. He has been approved by the relevant decision maker, whether it's the Secretary of State of that state or possibly even by a court after litigation. So one issue in those states would be, can that be reopened once the person has actually gotten on the ballot? And that would turn on the law of that state. Second question, which would be true both in those states and in the states where the process of getting on the ballot has not been resolved, is this required on their forms, and how stringently or liberally do they apply the requirements of their forms? That would be a second question. In other words, some states might be willing to waive a mistake. New York was not. So those are really sort of two big open questions. He's on the ballot now, and I don't know the exact number, but it's around 20 states that have been resolved. And that would turn on what their rules are on reopening a question like that. And I don't have an answer for that. And the second would be, was it required in these states to fill out this form, that to state a place of residence? That seems like a reasonable, kind of a normal bureaucratic requirement. And it is, I think, relevant to the 12th Amendment problem of making sure you don't have two people from the same state, which also happens to be your state. But then the question is, how stringently are they going to enforce that rule? And different state courts might have different policies on how strictly or loosely they enforce a rule like that.
Okay, stay with me, Rich. Coming up next on the Bloomberg Law Show, I'll continue this conversation with Professor Richard Briffault of Columbia Law School. We'll talk about Kennedy appealing to the appellate division in New York and broader election problems that may arise this November. I'm June Grasso, and you're listening to Bloomberg. Robert F. Kennedy Jr.'s independent presidential campaign suffered a blow this week when a judge in New York invalidated his petition to put his name on the state ballot, a ruling that could potentially create problems for the candidate as he faces challenges elsewhere. An Albany judge said the residence listed on Kennedy's nominating petitions was a sham address he used to maintain his voter registration and to further his political aspirations. Kennedy appealed the New York decision to the appellate division today. I've been talking to elections law expert Richard Briffault, a professor at Columbia Law School. Rich, before the break, you were talking about the possibility of an appellate court waiving this requirement for him.
It's not out of the question. I mean, there is a tension between, making someone, available to the voters, and it's not relevant to his seriousness as a candidate, either to his eligibility to be elected or his seriousness as a candidate. It doesn't affect whether or not he's over 35 and a citizen. That's which basically the eligibility to be president. And many states do require that you gather a certain number of signatures, that either you be nominated by your party, or that if you're running as an independent, you get a certain number of signatures, or if you're running as a new party, that your new party gets a certain number of signatures. And those are all designed to establish that the candidate is serious, not frivolous. He's presumably satisfied that. So I could imagine a court saying that a question that doesn't bear on his eligibility to serve and seriousness as a candidate might be one that we'd be willing to waive. So that would be one possibility. But the other would be that the court might also stick with what this lower court said is, for some things which are not that burdensome, it's best to be absolutely strict, because otherwise the chance of politics playing a role and different judges applying the same rule differently in different cases looms very large. So there was an argument from consistent application of a fairly straightforward rule that says you should enforce it, versus the argument that this does not really go to either his eligibility to serve or his seriousness as a candidate, so maybe you waive it. I mean, I could see it coming out either way. Third, that he is running for a national office, and there is some argument that courts should be less restrictive because, if he was going to be really in contention that having a rule like this to knock somebody off the ballot, that would affect a serious national candidate, sort of you don't want individual states to be doing that. He's a national candidate running for a national office, so I could see that as well.
Would that be a case for federal court or for state court? Or for both?
Well, for both, really. State courts can adjudicate federal constitutional arguments. It's a little bit like the argument in the Colorado Trump case about whether or not Trump was eligible for the ballot because of his arguable participation in the insurrection. and the U.S. Supreme Court saying, well, this ought to be resolved. This is a kind of a federal matter, should be resolved by a federal court. But of course, that involved an interpretation of a federal constitutional prohibition. This one does involve the interpretation of New York state law. And, one could argue that the only federal constitutional question here is this an unduly burdensome law or an unduly burdensome interpretation that would have the effect of impacting a national election. And frankly, requiring somebody to accurately fill out the line place of residence does not seem unduly burdensome.
And so what's your gut feeling about what an appellate court might do?
It's very hard to imagine that an appellate court will overturn this on the facts. But the real question is, what do you do with it? Do you decide to basically, do you let it go and say, well, we don't have to interpret it that strictly? Or do you do what the trial court did and say, well, our precedents require strict application and he's not a resident?
This challenge was brought by 4 voters with the backing of the democratically aligned Clear Choice Action.
Right.
And the Democrats have dedicated a substantial legal and ground operation to challenging third-party candidate ballot access.
That's right, although it's interesting now, at least according to recent surveys, it's now unclear from whom Kennedy pulls more votes, Harris or Trump. So it's true, and he began, obviously, he was a Democrat. He comes from obviously an extremely distinguished and famous Democratic family. I think Democrats assumed that he was going to draw mostly Democrats. I guess recent polling surveys suggest it may be closer to 50-50 as whether he's polling from Trump or Harris. So it's not 100% clear this is the right strategy for the Democrats, but this is the strategy they've been pursuing.
Liberal activist Cornell West apparently has been given help from Republican operatives in getting his name on the ballot in Wisconsin. Right. He would definitely draw from Harris.
Right. It seems likely. Certainly, someone who voted for Cornell West is unlikely to have voted for Trump.
I also wanted to ask you, so there are all these cases from the last presidential election that haven't been finally resolved. The cases over fake electors and false certifications and all that. In different parts of the country, you got the Georgia criminal case. I mean, are there outstanding questions because of those cases that might affect or complicate the upcoming presidential election?
I don't think so. I mean, I think, those are all about, the arguments about the so-called fake electors is that they were improperly presenting themselves as electors in order to create, chaos in Congress and undo the election. The states have procedures for deciding who wins an election and who the electors are. I think the bigger issue that's going to be coming up, if there's an issue at all in the current election, is how much discretion do the state or county boards of elections have to decide not to accept what appears to be the result of the election after all the ballots have been tabulated and retabulated based on some allegations that there was some fraud or misconduct or mistake, and wanting to hold it up until that's resolved. Traditionally and also by law in most states, the vote of the Board of Elections or the Board of Canvassers, or they vary from place to place, is supposed to be automatic. Once the results they've been tested, the machines have been run again, they're supposed to say, here are the results. In 2020, in a number of instances, Republicans tried to stop that and say, no, there are questions, and we're not going to vote yes. And this happened in Michigan and Wayne County. But ultimately, they all went through. This happened again a bunch of times in 2022 in state and local races, where local boards simply refused to certify the results because there were conspiracy theories, there were things on the internet saying, no, there was fraud. The machines were hacked. It happened, I think, in a county in Nevada, a county in Arizona. And in the end, they were basically ordered by their state courts to certify the results. The question that may occur coming up after the election is over is, will there be situations like that where local boards that decline to do what has historically just been an automatic, a ministerial function to say, here are the numbers, they've been counted and recounted, here are the numbers, and we submit them to the state. And the state says, here are the numbers, here's the winner. Are we going to be seeing county boards or possibly state boards saying, yes, we see these numbers, but we don't trust them, and we want to do more of an investigation? And of course, the problem with that is it's one thing for it to drag out for a congressional race or a Senate race. It really can't drag out for the presidential race. because there's going to be an electoral college vote on January 6th, and there's going to be an inauguration on January 20th.
Thanks so much, Rich. That's Professor Richard Briffault of Columbia Law School. Coming up next on the Bloomberg Law Show, is it the end of the road for student loan forgiveness? This is Bloomberg. The Biden administration has filed an emergency appeal with the Supreme Court, asking the justices to reinstate the president's SAVE plan, which would lower student loan payments for millions of borrowers. The Eighth Circuit blocked the plan last week after Republican states brought lawsuits arguing that the Biden administration did not have authority from Congress to enact the plan, a student loan repayment program that ties how much someone pays each month to their income. The administration is asking the Supreme Court to lift the lower court ruling. My guest is constitutional law professor Michael Dorf of Cornell Law School. Is the SAVE plan different from the program of student debt forgiveness that the Supreme Court invalidated?
Yes. I mean, it had some different details in terms of who was eligible and what you had to do to file. But the more important piece in terms of the legal aspect is that it relied on a different set of statutory authority.
And a 3-judge panel of the Eighth Circuit with 3 Republican appointees called the plan a vast assertion of newfound power. Tell us about that decision.
So the court had 2 issues to decide. It first needed to decide whether there was standing for the plaintiffs, which were a bunch of states that were basically led by Republicans. And it essentially relied on the Supreme Court case because Missouri is one of the plaintiffs. In the earlier case, the Supreme Court said that Missouri had standing because this corporation that Missouri had chartered to process loans, known as Mohila, could suffer legal injury, and that injury would be translated to the state. The dissenters dissented on that point in the Supreme Court, but that's sort of water under the bridge. So there was really no issue about standing for the Eighth Circuit to decide. The heart of the matter was whether this was something authorized by an act of Congress. And the Biden administration had a decent argument that if you read the literal text of the statute, it does seem to give the Secretary of Education broad discretion to, modify loans, to delay payments, including on principal. But the court said 2 things. First, they said, well, there are other parts of the same statutory scheme that expressly grant to the Department of Education the authority to forgive loans. And given that Congress did those expressly, it's unlikely that Congress would have intended for the Secretary of Education in this more general language to be able to forgive loans. The second thing they said was the language you quoted, which was that in the last few years, the Supreme Court, and especially Chief Justice Roberts, have relied on something that has come to be known as the major questions doctrine. And the basic idea there is that if an agency is going to be exercising power over a very large part of the economy or our social life, then you need to find authorization for the agency to do so in the express language of Congress. So it's kind of what's sometimes called a clear statement rule, although there's some debate among administrative law scholars and even by Justice Barrett questioning whether that's exactly how to understand it. But in any event, that's what the Eighth Circuit said. They said, look, this is just not the kind of thing that Congress has given you power to do. Maybe Congress could do that. Maybe Congress could do it itself, but they haven't done it.
In order to issue the injunction, did the Eighth Circuit find that there was irreparable injury?
Yeah, well, so that's the interesting thing. Yes, although the core of the decision, and the court says this, is likelihood of success on the merits. Of course, it's really kind of hard to see how there's an irreparable injury to Missouri because they're going to be collecting a little bit less in interest through this entity that they've created to process loans, but that there is not irreparable injury to the, hundreds of thousands or millions of borrowers who now have to pay off these student loans when they thought they were going to be eligible for some forgiveness. The court doesn't say that the borrowers don't have an injury or even an irreparable injury, but the court doesn't really get to the question of balancing of the equities, which is typically the last step in one of these decisions, whether to grant injunctive relief, which also applies for preliminary injunction and also applies to the review of an injunctive case.
Is this sort of the world with Republican courts post-Chevron deference?
Yeah, so the interesting thing about this decision is, you're referring, of course, to the Supreme Court's decision in the Loper-Bright against Raimondo case earlier this year. There, the court did away with this longstanding doctrine, over 40 years old, that said that courts will defer to reasonable agency interpretations of statutes. And certainly overruling Chevron made it easier for the Eighth Circuit to rule as it did. But remember, the Supreme Court invalidated the Biden administration's first student debt forgiveness program without having overruled Chevron deference. They just didn't apply it because they said you don't even get to that due to the major questions doctrine.
Republican attorneys general filed separate lawsuits over the SAVE plan, this one and one filed in Kansas. The 10th Circuit said the plan could take effect while the court battle continues. So now you have an 8th Circuit decision contrary to the 10th Circuit decision. Does this mean that the Supreme Court is going to take up the case?
Presumably, yes. What's interesting about this case and so many others the Supreme Court hears these days is there hasn't been a trial. This is on a preliminary injunction. Now, maybe you don't need a trial because it's really just a pure question of law, but it's technically what they were doing was addressing whether to keep a stay pending appeal in place or to modify it. But the bottom line of the Eighth Circuit ruling is that the program is enjoined indefinitely pending Supreme Court, reversal, or potentially, I suppose, the case could go back to the district court and somehow the district court could find the case comes out the other way. But, that would result in reversal almost immediately because here, likelihood of success on the merits means we think the merits favor the challengers, meaning the state.
Prepping for this interview, I started looking at the different proposals the Biden administration has come up with in order to try to give student loan relief. And there are, different versions of what they've done. And the Education Department is moving forward with a broader student loan forgiveness plan that it's going to enact in September. Is there any point anymore for the Biden administration to keep trying? It gets blocked every time.
Well, it depends on what you mean by a point, right? If the point is to actually deliver debt forgiveness to borrowers, probably not. You would think that if you want to deliver debt forgiveness through existing statutory authority for one of the federal agencies, you would start with the strongest case for doing so. And, the backups tend to have somewhat weaker arguments. Although I will say that the argument for the program that was just struck down didn't rely on the kind of emergency theory that the previous one did. So it's possible that they will eventually hit upon something that the Supreme Court and the lower federal courts accept. I just think it's not very likely.
I think in your column you said that you think that there's no way that there'll be any kind of debt relief, certainly before the end of the Biden administration.
Yeah, I think that's right, just given the pace of litigation, right? So you could throw a Hail Mary, you could appeal to the U.S. Supreme Court and hope that they side with the 10th Circuit rather than the 8th Circuit. But, that, again, given how closely the 8th Circuit logic tracks the logic of the Supreme Court's own opinion in Biden against Nebraska, the earlier case, I don't think that's going to happen.
Why are the Republican states so bent, so driven to stop any kind of student loan forgiveness? Is it just because it's a Biden administration initiative, or is it some other reason?
Well, I think they've got three kinds of reasons. One is, anything you're for, I'm against. I think that there's some of that going on here. But I think a second piece is that, they're hostile to executive branch agencies doing things that Congress hasn't clearly authorized because they're hostile to the administrative state. And you saw that in the overruling of Chevron. You've seen that in the major questions doctrine. You see that in these suggestions by various conservative justices that they'd like to revitalize the so-called non-delegation doctrine. I should say that the Republicans in Congress are much more hostile to the executive doing things that aren't very clearly authorized by Congress when it's a Democratic president than they are when it's a Republican president. But that door swings both ways. That's just generally true. So, and then the third thing I'll say is that, there are, I think, legitimate policy reasons to, if not necessarily oppose student debt forgiveness, to think about the issue in a broader perspective. So it's true that people who borrowed money to go to college or even to go to grad school or professional school and now are saddled with a lot of debt find that difficult, especially if they didn't have, fixed rates, which you typically don't for these things, especially as we've been in a high interest rate environment for the last couple of years. But so do other people, right? There are, if you borrowed money to start a business, you could be saddled with a lot of debt. If you went to a less expensive college than you might have gone to that might have given you a somewhat more prestigious degree because you didn't want to be saddled with debt and you paid for your education out of pocket or you got loans that aren't covered by one of these relief programs, then you might say, well, I'm similarly situated to the people who are getting this relief. I should get the relief as well. And there's, of course, a revenue hit to the federal government, which means either you're going to run larger deficits or you're going to have to cut somewhere else. So it's not as though student debt forgiveness is a slam dunk on the policy side. And so I think it's quite possible that some Republicans, probably even some Democrats, think that while this may or may not have certain political impact, and it's certainly valuable to the people who get the forgiveness, and they certainly, could use it, it's not necessarily the best policy, all things considered.
Next step, I guess we'll see if the Supreme Court takes the case. Thanks so much, Mike. That's Professor Michael Dorf of Cornell Law School. And if you're one of the millions of borrowers under the SAVE program, the Education Secretary said the department will place all borrowers enrolled in SAVE in an interest-free forbearance while the Biden administration continues to defend the plan in court.
And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.